All right, part two of our module this week is going to look at those different common negligence applications. So, like I said in the first video, now we're going to explore the common negligence lawsuits that we see for K&R organizations and hopefully talk a little bit about how we can prevent these things from happening. Okay, first one here is negligent supervision. As I'm sure you're already very aware, our field in particular involves a lot of different versions of supervision, right? A lot of what we do as K&R practitioners is supervising events, supervising activities, supervising programs. So it's probably not surprising then that a lot of times we see lawsuits involving negligent supervision, right? Or rather, this failure to provide the proper level of monitoring or supervising, which ultimately leads to an injury for a participant. So, what's probably most important when trying to prevent negligent supervision is really thinking about the individual job duties of someone working. Think about it from your own perspective as an intern or a full time job that you'll have one day. What exactly are my duties and how do they relate to supervision and providing proper supervision? And obviously, every job is different, every organization is different in terms of what those look like. So maybe the better question to ask is, how do we determine what level of supervision is required? And there are some factors that we can base this on to really determine how much supervision should be provided. And you can see I've listed those here. So certainly we want to be able to assess the risk level or the danger level of a particular activity, right? We would probably look at something like a college tennis match as being fairly low risk and having a pretty low danger level, right? So that might impact the level of supervision and the number of supervisors we put on that particular activity versus if we were putting on some kind of racing event involving high speed racing, that's going to obviously be a much higher risk activity with more potential danger. That's going to impact the level of supervision and the number of supervisors we provide. Same is true of facility space, right? So we need to think about the space involved and what that means in terms of how much supervision can be provided, how many people are going to be in a certain space. Certainly, whether an event is happening indoors versus outdoors, also going to play a role in determining that. Knowing whether or not the participants you're dealing with are experts or maybe novice at the particular activity is important, right? You have a group of people who are novices, meaning they have very little experience or practice with the activity or program, probably going to need a higher level of supervision versus, a group or individual that is an expert and has been doing it for a while. And then the same is true for minors versus adults, right? And that's probably fairly self-explanatory, but certainly activities involving children probably going to require a higher level of supervision than that of activities involving only adults. Okay, so once we assess those factors, we look at the full picture, then we can probably determine whether or not we are looking to provide either general supervision or specific supervision. And keep in mind, these are pretty broad terms, and we are generalizing a bit here. But it's at least a starting point to determine what level of supervision we should be looking at. So you can see general supervision, we're looking at maybe low risk activities, group settings. These things can happen in large facility spaces or outdoor spaces. All of those factors would probably push us towards something more like general supervision, where we have a handful of supervisors overseeing a low risk activity with maybe a larger group of people. Where, on the other hand, specific supervision, now we're looking at more high risk activity, maybe more individual based activities or even smaller group based. And typically when we're providing specific supervision, we're also dealing with maybe more of a controlled space, right? So one where we can actually provide that more individualized attention or specific supervision. Okay, the next common negligence application in our field is negligent medical care. So you can see here there are basically two prongs to negligent medical care in our field. One is dealing with preventative health concerns, so having systems in place that allow us to properly screen for potential injuries having policies and procedures in place and actually enforcing them, and then having proper emergency planning in place. All of these deal with trying to be more preventative, and trying to avoid there being some kind of negligent medical care incident where we are not able to get someone the proper care that they need. And the other prong of this is just emergency medical care in general. So, making sure we have the ability to provide emergency care to people that are at our facilities and at our events, but also making sure that we're able to get people from the outside, say like ambulances, into our facilities and get those people out if it is that severe. If you've ever been to a football game at ISU, you've probably noticed, or maybe have noticed, that there's always an ambulance parked at one of the gates. Basically, it's pointed out so that if something were to happen to, say, a player or a fan, that they could get that person to the ambulance and they could leave immediately, and they have a pathway out of the tailgating lots. So these are some of the things that we can be thinking about in terms of preventing some kind of negligent medical care situation. Unfortunately, when these things do happen, they can often lead to death, which is obviously something we want to avoid. Some of you might be familiar with this case involving Jordan McNair, who was a football player at Maryland. So just, I think it's 2 years ago now, he had, a medical event while on the practice field. Basically, there's this hour of time, this gap in time from him starting to have, medical issue to him actually getting into an ambulance. And essentially, he ended up dying from those issues that he was dealing with. But the major questions for obviously the athletic department and the athletic training staff is, how did this happen? How was there an hour of time in between when he started showing these severe signs to when he actually got medical care? So, it's an unfortunate story, very sad story, but I think an important one. And I've shared this Ringer article for you on ReggieNet to look at, because I think it really points out some, failures by this organization. And, we can certainly learn from some of these things. One other thing I want to mention about negligent medical care is this concept of fraudulent concealment. Basically, this is, a legal premise where, a medical practitioner or someone in an administrative role basically has information about someone's medical condition, but they withhold that information in an effort to keep that person, playing or participating in an activity. Obviously, this is a big no-no, right? And someone can be found, very negligent in these instances. And unfortunately, we've seen this a lot too, both at the high school level, the college level, and at the professional level. So it's certainly an important concept to be aware of, and know that anytime any information about a medical condition is known, that needs to be shared with the party involved. Okay, moving on now to this area of negligence that I think is really important. And basically, these are employment torts. So negligent hiring and negligent retention fall under this kind of umbrella of employment, because they deal with really human resources related negligence. So this first one, negligent hiring, you can see is pretty straightforward, right? It occurs when an employer or someone doing the hiring breaches their duty to hire safe and competent personnel, right? So basically, they did not take the proper steps to screen this employee before bringing them on board, right? They didn't do background checks, they didn't do reference calls, they didn't take the steps that they needed to take in order to find out, important information that certainly could lead to negligent acts by the person if they were hired. Negligent retention, on the other hand, occurs when you have an employee that's already on staff, and in these instances, the employee acts out or fails to do their job in such a way that puts others at risk, and the employer fails to remove them. Right, so they continue to keep them on staff despite the fact that they know that they could be causing potential harm. So it's important to be aware of these two employment negligent acts, because they can be very costly for K&R organizations. Typically things that fall under this umbrella of employment law tend to be very high dollar settlements and claims. So it's very easy to kind of avoid some of these issues, as we've already mentioned, doing basic things like background checks, reference calls, drug tests, things like that can really give you a lot of information to help you avoid negligent hiring altogether. And then, taking swift action once you see that an employee is not living up to that standard of care that you expect from them can help you avoid negligent retention. And we saw this with our, case study last week involving Big State University, right? We saw that, the university gym manager knew that the employee had been coming in late to work, had been sleeping in, but they failed to remove them. And therefore, that led to them also being held accountable in that case. All right, moving on to our last example of negligence cases. And this involves this concept of premises liability. So you can see here, premises liability is basically, an organization has been negligent in providing a safe environment for its patrons. Basically, we know that there's a standard of care expected to provide a safe environment anytime someone uses a K&R facility, and negligence in these cases means that they failed to do that, right, in some way. Whether it be based on the equipment that has been unsafe for patrons, or, we talked about the baseball case earlier, not having proper netting or glass to keep people safe, to just not properly doing security checks at an event. All of these things, could fall under this category of premises liability. All right, as we think about premises liability, the thing that we really need to identify is that there are different levels of duty owed to participants based on their classification. So you can see here we have 3 different classifications for our participants: invitee, licensee, and trespasser. Now, you can kind of push off this trespasser one to the side because I'm sure, as you all know, kind of the definition of a trespasser is someone who's entered a property, without permission to do so. So essentially, we owe very little duty to trespassers in providing a safe environment to them. The 2 categories we really want to focus on are invitee and licensee. So you can see here that as K&R practitioners, we owe our highest level of duty to our invitees. These are people who have been invited onto our property and that are providing some kind of monetary exchange for that access, right? So basically, the K&R organization is benefiting financially from that individual being on their property, and therefore are owed the highest level of care in providing a safe environment. So this could be someone paying a membership fee at a fitness center. This could be someone showing up and paying a fee to use a rock climbing facility. This could be someone paying for a ticket to attend a sporting event. These would all be classified as invitees, right? Because they're providing some kind of financial benefit for the facility owner. And therefore, not only do they owe them a duty to sort of review the grounds and make sure that there's no obvious risks, but they also owe them a duty to make sure they're doing regular maintenance checks, making sure they're staying up to date with all the safety compliance associated with that particular organization. A licensee is our next participant that I want to talk about, and licensees are also invited onto someone's property or an organization's property, but the biggest difference between a licensee and an invitee is that there is no financial benefit provided by the licensee. Right? So because of that, they are not owed quite as high a level of duty of care in providing a safe environment. I always use the example of, let's say that you had a house, you invited some friends over, say you have a pool, and they're going to use your pool. Well, they're your friends, so you're not going to charge them an admission fee, at least hopefully not. So they would be classified as licensees, right? Because you've invited them onto your property, but there's no financial benefit coming from them. So you owe them a moderate level of care in providing a safe environment, meaning that, if you know that there are some risks associated with your pool or the setup around your pool, you need to tell them that, but you do not have to go out of your way in the same way that we would for, let's say, an invitee who is providing that financial benefit. I have posted an article on ReggieNet, this one involving fairly recent lawsuit, Reggie Bush, who had an incident where he suffered some pretty severe season-ending injuries this is back when the Rams played in St. Louis. And if you ever had the chance to go to that Edward Jones Dome, you'll know that there's basically this cement ring around the field. It's an indoor facility, and it had been troubling for athletes for quite a few years. And Reggie was really the athlete that sort of put a face to this issue and filed a lawsuit against the team and the facility owner. So make sure you take a look at that article. I think it's a really good example of how there is this expectation to provide a safe environment for invitees, and that if that standard is not met, the organization could face some pretty severe financial penalties. So make sure you take a look at that article when you get a chance. Okay, really quick wrap up here. In terms of negligence, we've covered a lot now. So we've covered negligence from the perspective of the plaintiff, right? You've covered those 4 elements, and just make sure that you understand those elements, that you can identify them, and that you can actually apply them if you were given a scenario. And now after looking through this module this week, now you know about negligence from the perspective of the defendant. Right? You know the different defenses available to someone if they're sued for negligence, and you also know the different common negligence lawsuits, which can, again, help prevent these things from happening just by being aware of them. And then finally, just be aware of where negligence falls on that tort law spectrum that we introduced last week. And we will continue to bring up that tort law spectrum as we move into some other subunits in our tort law unit. But just make sure you have a good awareness of where negligence falls on that spectrum, as I think it'll all become a little bit more clear as we work through some of these other topics as well. All right, that's all I have. Thanks.